Good news. Court grants Nnamdi Kanu the permission to be free as ordered by the UK Judiciary. I greet you all, my dear listeners in the house. It's a pleasure meeting you all still on this very channel. Yes, we are appreciating everyone that has contributed in one way or the other in our broadcast, both the ones of yesterday, 3 days ago, and also today. In fact, you are all doing wonderfully well. We appreciate you. You see, what is happening in our country, Nigeria, today is something that we need to be carried along with, because anyone that is not informed of this country, definitely that person will be deformed. So let us not be pushed away. You understand? And that is just the humble truth. All right, my people, looking at this very content that has just been revealed to us right now, I tell you, you will not believe what I'm just passing to you now. You will not believe it, and it is just the humble truth. Nnamdi Kanu have just gotten permission to be free from detention, as ordered by the UK Judiciary. In fact, international community, international organization, international country, everybody have been having a legal sitting on the issue of Nnamdi Kanu, to have a test to know if truly Nnamdi Kanu is permissible or is normally supposed to be free from detention, of which they have sat and they have seen and they have concluded. But in Nigeria, it is only Nigeria that I see that is still playing a headstrong, saying that Nnamdi Kanu doesn't deserve a release. And that is why. That is because Nigeria is the country that wants Nnamdi Kanu to suffer for this very cause. All right, let's quickly check on the content, my dear listeners. This is Evening News. Aloy Ejimako, the special counsel to the indigenous people of Biafra, IPOP leader Mazi Nnamdi Kanu, has disclosed that a British court has made an order granting Kanu permission to apply for judicial review of the UK government's reluctance to intervene in his extraordinary rendition from Kenya to Nigeria last year. Ejimako, in a statement, said it was Kanu's younger brother, Kingsley, that initiated the case start. In the High Court of Justice, Queen's Bench Division Administrative Court. Respondents in the case are the Secretary of State for Foreign, Commonwealth and Development Affairs. He cited the notification of the judge's decision on permission to apply for judicial review in the British High Court, stating that Mrs. Justice Eleboga ordered that the permission to apply for judicial review is granted, sequel to the consideration of the document lodged by the parties. He said that it was also ordered that in granting Kanu the permission to apply for judicial review, the application is to be listed for 1 day at an in-person hearing at the Royal Court of Justice, and the parties are to provide a written time estimate within 7 days of service if they disagree with this direction. Ejimako further stated that the claimant's challenge borders on the refusal by the respondent to communicate to the claimant and his family as to whether the claimant's brother has been the subject of extraordinary rendition. He stated that by the case management direction, the claimant, among other conditions, must pay the relevant fee to continue the application for the judicial review within 7 days of permission being granted, as failure will result in the court sending the claimant a notice requiring payment within a set time frame, normally 7 additional days. The respondent and any party who wishes to contest or support the claims must file and serve detailed grounds and any written evidence or document not already filed in paginated and indexed bundle in both hard copy and electronic copy within 35 days of permission being granted, with the detailed grounds made as concise as possible, and with the detailed ground made as concise as possible and must not exceed 40 pages without the court's permission. The respondent may rely on her summary grounds as the detailed grounds. In doing so, she should inform the court and the other parties in writing within the time set for filling the detailed grounds. Any application by the claimant to serve evidence in reply should be filed and served within 21 days of the date on which the respondent serves evidence pursuant to paragraph 2 above. My people, forget it. Nnamdi Kanu is a free man. You understand? He's a free man and he's unstoppable. You understand? It's unstoppable. You see, President Muhammadu Buhari is purposely doing what he's doing because he already know that Nnamdi Kanu has all the support that he needs. So for him to just keep him till his tenure is over is what he's just trying to do. That's it. I'm telling you, that's what he's just trying to do. Right, my people, let's try to hear from you and to know what your own take and what your own opinion on what has just been reviewed by the US courts. Let's know what your opinion could be. Don't forget to leave them below the comment section. Click on the subscription buttons as well as the bell buttons to get updated each time we upload any new videos. Thank you.